the first event of the Center for Judicial Cooperation, and we are very pleased to have the opportunity to have two of the editors of the recently released book dedicated to the Return Directive. And I have to thank, first of all, Angelica, before I forgot, Angelica and Frankie and Matthias, that have helped us, because as you may have seen, unfortunately, this event was originally planned as an hybrid event, but we had to move into an hybrid, from an hybrid one to an online one, because the situation regarding the pandemics has not been improving in Italy. And we did have the need to move and to limit the possibility to people to join us in Florence and enjoy not only our company in person, but also the possibility to experience the well-known UI gardens and outside. So I am, I would like to introduce myself. I'm Federica Casarosa. I am part-time professor at the Center for Judicial Cooperation. I worked here at the center for some time, and I have the opportunity to contact and collaborate with some of the people that will be present to this event. But first of all, I would like to have some housekeeping for this event. So in order to make sure that we have the opportunity to coordinate well and have all the advantages of a virtual event, because as you may understand, the virtual event allows us at least to enjoy the opportunity to participate from different parts of Europe, but also to have the opportunity to have people coming and also listening to us from different parts of Europe. So all the panelists are available on the screen for you. So we have a really packed program. So Galina and Madalina have organized this book presentation with really so many inputs that I hope that there will be sufficient time for the discussion. So all the people that will participate to this event and will follow us online will have the opportunity to present their views and their suggestions or comments, but only at the latest moment. So at 5:30 we will open up the discussion, and you will be able to share your views. If you need to anticipate some of the questions, if they are relevant, please use the chat, but we'll only address the questions in the discussion time. So let's move to the substance. So I have the pleasure to present the book dedicated to the Return Directive. This is, we can call it as a byproduct of one of the CJC collaborative projects that has been Migration Policy Center and CJC projects, that is ReDial. But this was obviously a step forward. So the projects were from which this book has started from was the opportunity for judges and academics to share their views and experiences and competencies at the same joining the same table, and having a dialogue that is not just in terms of what should be as a normative level, what should be interpreted from the directive, but also what is really done by the courts and by the judges in practice. So this is really an effort that is that is not just a one-time episode in the activities of the Center for Judicial Cooperation, I may say, but also this is an underlying element that goes through what is the important role of judges in the interpretation of EU law, but also in the effective application of the norms. And here, this is important because they have the opportunity to teach to us as academics what is really the ways in which the problems may emerge before their courts. And in this effort, Madalina, Galina, and Philippe have the power to coordinate and to look at different phases of the procedural aspect and go through what has been the activities of judges, the problems that emerge, and make them clarify the guidelines that could be used for further use by other colleagues and other foreign colleagues, other judges. So this is very relevant. This is really an effort to make a book, to make not just let's say a brick within the knowledge of the overall academic community, but this is really something that helps judges to understand and to go further and to improve their, not only their knowledge, but also their application of EU law. So I will not take more time for my presentation. I will hope that Galina and Madalina will present the results and the presentation of the results of this book. But I will also have the opportunity to have as a first speaker, there will be also European Parliament member Tineke Strik, and she will provide us her views and her the opportunity to present what has been seen from the legislator's side. So I will not take time to present the background of each of our presenters, because they will just take time and you can Google all of us easily and find us easily. So I will just give you the floor, Mrs. Strik, and allow you to, if you have a presentation or a PowerPoint, please feel free to take control of the presentation. So the floor is yours.
Yeah. Oh, I was not muted. So
yeah, no.
Thanks a lot for the invitation on this very promising and interesting webinar that you organized. And also thanks a lot for launching this book. I think it's very timely that we have this book now, as the negotiations will start, of course, on all parts of the new pact proposals, and that we are still in the process of negotiating on the recast Returns Directive. I think it can be very helpful in order to make sure we have, on the one hand, evidence-based policies, but also make sure that the policies will be in line with the case law, which is developed until now. So I was asked to say something about the new pact and about, of course, the recast return procedure, because I am the rapporteur of the recast return procedure, and I'm coordinating the LIBE committee affairs for the Greens. I will not go too deep into the whole new pact, because it has very many different elements, but I would like to touch upon the issues where return is also at stake, because the focus is to a large extent also on return and readmission. I think that, and this is what I have to say more in general, that the preservation of the first country of entry criteria, which formed actually the main obstacle for getting a fair responsibility sharing under Dublin, coupled with a newly introduced border procedure, will increase the pressure on the border countries, especially while it will largely depend on national capacities of immigration authorities, of lawyers, of judges, if the procedures will indeed be fair and short. Detention is not always obligatory, but it is allowed, and I think it is to be expected because member states will want to prevent absconding. Although the border procedure is only mandatory in a certain category, namely the asylum claims of nationals coming from a country with a recognition rate of lower than 20%, which is already to be influenced by the countries themselves, of course, I think many more people will be processed in the border procedure because member states are allowed to do that in many more cases. For instance, if the application is made at the external border, if a person is apprehended after irregular border crossing or disembarked after a search and rescue action, and also decisions on admissibility. Among them also, if the country of safe third, if the concept of safe third country can be applied. And therefore, I don't see any reason why this proposed system will bring an end to Moria-like situations, as all the elements that create this situation will continue to be there. The pact strengthens the linkage between asylum and return procedures, and this is especially applied in the border procedure, where asylum seeker is treated as if he is not yet on the EU territory. And during this period of fiction of non-entry, people are screened, can undergo an asylum procedure if the criteria are there, and if they are rejected, the return procedure can take place there as well. And all stages of this procedure can take place in detention. And as border countries will have the largest burden and returns will be very difficult to execute in many cases, there is a risk of long detention periods of returnees, despite, of course, the maximum periods that are there on paper. We now see what's happening on Moria. This is all a flagrant violation of the current rules that we have. The proposal obliges member states to take a decision to reject the asylum claim and the return decision at the same time. And this obligation actually mirrors the proposal in the recast Return Directive to take a return decision immediately after a decision ending the legal stay of the third country national. And the newly proposed Article 53, first paragraph on the Asylum Procedures Regulation obliges member states to ensure that the procedure against the rejection of the asylum claim and the return decision are dealt with in the same procedure and for the same bodies and courts. The Commission wants to avoid delays in that way, but it also may create tensions regarding due process and fair trial. I think this is something that we really need to assess carefully. And more in general, I think we need to be alert on the time limits in the border procedure, especially on appeal. Also in crisis situation, because then the time limits are even shorter, to make sure that there is always an effective remedy in the way that the Charter, but also the CGEU has defined it. A border procedure on return, which was proposed in the recast Return Directive, has now been transferred to the Asylum Procedures Regulation proposal. A rejected asylum seeker has to stay in a border accommodation if it's refused entry. And that can be done for a maximum of 12 weeks. Most of the provisions of the Returns Directive are applicable then, but the period for a voluntary departure may not exceed 15 days. So that's clearly a derogation from the Return Directive. They can be detained if there's a risk of absconding, if they hamper the preparation of return, or if they pose a risk to public policy, security, or national security. And this is interesting because these three grounds are explicitly mentioned. At the same time, it says that Article 15 of the Return Directive is applicable. So I don't see clearly the added value of this. I hope that still the requirements on Article 15, like, that there is a real prospect of return, for instance, will be applicable there as well. So this can be done, this detention, for 12 weeks. And yes, for 12 weeks, the detention can be prolonged, but no longer at the border. So then people need to be transferred to another place. And the 12 weeks include the maximum period of the Return Directive. As the Return Directive thus offers the opportunity not to apply the Return Directive near the border or in border situations, the Asylum Procedures Regulation requires that in case of detention over there, that at least some minimum requirements of the Return Directive are applicable. And I think that you can say now that we can expect more return procedures to take place at the external border. It creates even stronger arguments for simply deleting this optional clause in the Returns Directive, namely that they can derogate or not apply the Returns Directive in border situation. I think this is also important if you look at the pushbacks taking place at the border, that we really should get rid of this derogation. The solidarity system is very complex, and I'm sure that you already had more discussions on that. But what you see is that what the new element is, of course, is the return sponsorships. In case of migratory pressure, member states can choose for either relocation, support in operational sense or financial, or return sponsorships. And if that turns out to be insufficient, they can still choose between relocation and return sponsorship. And actually that means, or we have to find out, but that would mean that the other member states is going to make efforts in order to get a laissez-passer or an agreement from the country of origin that the people can be returned. And during the first 8 months, the people will still stay at the external border in the first member state. If then the return still has not happened, the second member state needs to really physically take over this returnee. What is not clear to me is that it says that this return procedure is transferable, meaning that it can also be applied by other member states. And what I still don't have clarity about, if then there's still the fiction of non-entry over there at the moment that this returnee is being relocated to another country. And what I think is also good to bear in mind is that maybe it can be the case that returnees will be brought to a member state with very good relations with a specific third country in order to facilitate the return. But will that always be the country of origin? If you look at the recast proposal, you see that the definition of a country of return is being extended to also a transit country, but also any other country. So suppose that there is a third country having very good relations with the member state. Would that mean that then we have the risk of more returns to a country where a person has never been before, has no links whatever, with the risk of fundamental rights violations or no access to basic safeguards and needs? So this is the only thing I want to say about the new pact. Then some words on the recast Returns Directive, and I'm very happy that we are able to have parallel negotiations, because now I already see some reasons for having very clear positions on the recast Returns Directive. I have tabled my amendments already in February. The other groups have done so a few weeks ago. We had a consideration of the amendments only last week. So now the negotiations are about to start, depending on the online capacity of the LIBE committee. But it's very clear that we see a number of contentious elements in the Return Directive recast proposal that really divides the European Parliament. And it will be very difficult, but I hope we will in the end reach an agreement among each other. And actually, I hope we can get away from rhetorics, but really look at what is an effective return policy, because actually everyone agrees with that. but there's a really different interpretation of what is effective. For instance, deleting the voluntary departure period, does it make a return procedure effective or not? Prolonging detention period, do we have any proof that it will lead to more returns? And I think also, if you talk about effective return procedures, you should also apply the whole objective of the return procedure. And that's not only returning people, but also do that in a way that is compliant with the fundamental rights and the principle of proportionality. And the Return Directive very clearly is based on the principle that voluntary departure is to be prioritized. This is still the case. The Commission did not depart from that. But if you look in the recast proposal, I'm very concerned that in practice, this principle cannot be safeguarded anymore. And this is immediately one of the points that we are divided upon. The recast proposal says that wants to change the minimum, delete actually the minimum period of 7 days. So that would mean that a voluntary departure term is to be given up to 30 days. And that means that member states can, in principle, in all cases, refrain from a voluntary departure term. Furthermore, there is a mandatory provision obliging member states to refrain from a voluntary departure term in 3 cases. Manifestly unfounded cases, a threat to the public policy or national security. But I think the most sensitive issue is in case of risk of absconding. And why is that so sensitive? Because the directive lists a non-exhaustive list of 16 criteria. And if those criteria are applicable, member states have to refrain from a voluntary departure term. There needs to be an individual assessment still, but it's not defined what the scope is of such an individual assessment. The concern is, and I also read that in the book, in your book that I was able to read before, that there's in many member states the risk of a sort of automatic application of the criteria, kind of ticking the box. And then you may create a situation that the burden of proof is reversed so that the returnee has to prove that there is no risk of absconding. So if you look at all these, both provisions, so the whole constellation, actually, I don't see in what way we can guarantee this voluntary departure anymore, especially while these criteria for risk of absconding are very, very vague and apply to most of the undocumented migrants, more specifically the rejected asylum seekers. Well, some of the groups want to shorten the list of criteria. Others want to delete the obligatory nature of refraining from a voluntary departure, and others are really okay with it and they really support the Commission proposal. So we have to see what will come out of this. And maybe it's good to say also, because we did not have a lack of evidence or very good substantiation from the Commission why we needed these proposals, why we needed to have the Return Directive amended. We therefore did a substitute impact assessment last year already, or even, last year. But then still, we did not know how member states are deal with the current Return Directive, because the Commission has this obligation to do that every 3 years. But the last one already dates back from 2014. So we decided as a LIBE committee to do our own implementation report. It's being negotiated right now, but the study is already available. And it was very difficult to get all the information from the member states. So it's much better if the Commission does these studies. But yeah, this was also a second best. But really, in order to have a look at the national practices while we are negotiating, to see does it lead to any solution or not? But I think that your study also is very complementary to that. So this is the risk of absconding, which is really, we have 50 amendments on that, so there will be a lot of negotiations. The obligation to cooperate, there are also a lot of amendments, because at the moment in the recast proposal, there's actually only an obligation to cooperate for the returnee, whereas others say, look, there should be a balance. There should also be obligations for the member state, for instance, in providing information, guiding people to lawyers or assistants or whatever, so that there's more balance, that you're really cooperating and not only complying with certain rules. Yes, then the assistance of returns, there's also a big, well, we are a little bit divided to what extent you need to assist the return. I think it's very important, and also that we have post-return monitoring provisions in place, that we really know what's going on and that we can act on that, you know, and in order to prevent new violations of fundamental rights if things are really go wrong in the country. For instance, with Afghanistan, with children, we have very concerning reports, but it is more on an ad hoc basis and not structurally. Then on legal remedies, we really need to make sure that there's a compliance with Article 47 of the Charter, so that there's an automatic suspensive effect, and there are some different opinions. And then on detention, you know the proposal, of course, with a minimum period in legislation, adding public policy as a ground. And there's also a different opinion on that. I think, but maybe you have other opinions, that this adding this ground of public policy, maybe at odds also with what the court has said regarding the reception conditions directive, because it can never be sufficient that there is a ground on public policy. It still needs to be to serve the objective of the Return Directive, namely preventing absconding and make sure that the return can take place. I have proposed myself a vulnerability check before or immediately after people are taken in detention, in order to make sure that people are fit for detention, because a lot of things go wrong in practice. And what I also proposed is more provisions on the circumstances and the rights of detainees, because actually what you see in practice, administrative detention should require more liberties and more rights for people compared to criminal procedures, because the objective is only that they cannot abscond. But in practice, you often see that they have less liberties because there's less investment in their detention circumstances. I was in the European Parliament. I was member of the Parliamentary Assembly of the Council of Europe, and in the Council of Europe, we had very far-reaching stage negotiations on recommendation on conditions and circumstances for administrative detention, until the moment that the European Commission came in, saying, look, this we cannot agree with this, because that may frustrate the negotiations we need to have on the Returns Directive and on the Reception Conditions Directive. Therefore, the recommendation, the text was completely frozen. Nothing happened with it anymore. And therefore, I thought, then they have to be in the recast Return Directive, but because we need to have more safeguards. What is very controversial to finalize is, or to finish this, is detention of children. Because there are actually a lot of people in the European Parliament that think that children should never be detained, because we know that it's harmful to them, and that the best interest of the child should be a primary consideration, of course, if you look at the Charter. But some others really insist in having this possibility. So we don't know how far we will come with that. I think that these are the main points. I hope they were useful to them. And please know that we are always willing to get your information, your input. If you have seen the amendments, if you have specific ideas of argumentation or whatever, they would be very much welcome, because I really think we need to cooperate very closely as scholars and policy makers. Thanks a lot for your attention.
Thanks a lot, Tineke. It was really interesting, and you really pointed out to the problematic aspects that emerge that I heard and learned from the book, but also from the opportunity to speak with my colleagues on this topic. And I suppose that one of the striking a balance between effectiveness of a procedure and the safeguard of fundamental rights is really an effort that is difficult to achieve, also in terms of addressing the differences in the procedural rules that are applicable in each country. So I see that the effort is to introduce a kind of harmonized system that could safeguard this as a fundamental, as a first step towards the effectiveness, but also making sure that this is a shared responsibility for all member states. So it's really interesting. I have to ask you if you will be available to stay with us until the end of the event. If it's so, that's perfect. So I will be happy to make sure that all the participants, all the attendees to this event, to this webinar, will be able also to provide you some hints and some additional comments. Without further ado, I will now present in 2 minutes my colleague Madalena Moraro, which is one of my friends and colleagues from the Center for Judicial Cooperation, but also a scholar that has dedicated the last her last years of studying and research to migration and asylum law. So I will giving her the floor and presenting in particular what is the first part, the results of the first part of the book. So you will really receive the grasp of what is emerging from the analysis that has been tackled within this first part. So please, Madalena, the floor is yours. If you want to take control and present also any PowerPoint, please feel free.
Thank you very much, Federica, for the kind introduction and also for chairing this session. And first of all, I would like to start my presentation by thanking all the speakers and the discussants for accepting my invitation to discuss the findings of the book, and also to the authors, both those who are with us online, as well as those who could not make it, but who will be watching the recorded meeting. So this book is, without a doubt, actually the product of a collective effort of all the 27 authors. So this book, Law and Judicial Dialogue on the Return of Irregular Migrants from the EU, has gathered not as many as 27 authors. I finally take the opportunity to properly thank my co-editors, and in particular Galina Cornelise, who is joining us today, and who has been more than a co-editor, but has also been a mentor for me throughout the editing process. And as well, Philippe de Brucker, who has been the initiator of the research projects Contention and Redial that have provided the research carried out in this book with empirical evidence. I'll turn now to the overarching theme of the book, which, as already anticipated by Federica, is the role of national courts and judicial dialogue in shaping the implementation of the EU Return Directive, which is the flagship of the EU's return policy. I would say, and we've made sure to emphasize that in the introduction of the book, that the directive is one of the most controversial instruments of the EU immigration policy, being not only one of the longest negotiated, approximately 7 years, but also one of the most criticized and most litigated instruments of European migration management, judging, of course, by the number of preliminary rulings delivered by the European Court of Justice. Nonetheless, an instrument that has started out as the Directive of Shame, was the campaign that surrounded the adoption of the directive in 2008. And particularly it was criticized actually for promoting at the EU level one of the most restrictive domestic return policies. At that time, it was said is the German return legal regime. Has nevertheless, in some respects, become a normative example for legal orders around the globe. For instance, in his 2012 report on the expulsion of aliens, the United Nations Special Rapporteur referred to the Return Directive as containing extremely progressive provisions that are far more advanced than the norms found in other regions. So what has changed between the 2008 Directive of Shame campaign and the 2012 praises of the Return Directive as a sort of directive of protection? And the book argues that this change of perception is to a great extent due to the European and national courts interpretation, which, empowered by judicial dialogue, have helped to maintain a balance between effective returns and human rights protection. This extensive judicial shaping of return policies would have been impossible before the adoption of the Return Directive, given that actually return policies are one of the strongholds of national executive, over which courts were granted limited judicial control. And even when such control was exercised, it was often quite differential to the executive decision-making. So one of the unexpected results of the Return Directive has been to harmonize areas of law that were intentionally left out of the scope of the directive, such as, for instance, procedural safeguards. This outcome is illustrated more in depth in the chapters that are part of part 3 of the book. Another example is the use of criminal law for sanctioning irregular stay and crossing of border. This was meant to be outside of the scope of the Return Directive, and the exact effect and impact of judicial dialogue on the use of criminal law is very well elaborated by Galina Cornelise in her chapter in part 1. And these are, let's say, just some of the many other issues related to procedural organization of return. Now, one of the key findings of the book is that actually the Return Directive has empowered courts to scrutinize and strike down member state policy choices when these did not conform with the dual objective of the directive, that are effective returns and protection of human rights. And this is an unexpected result given the wide regulatory flexibility recognized by the directive to the member states. Before I present some of the most interesting findings of part 1, and I would limit in my presentation only to part 1 because Galina will continue with more insightful reflection out of part 2 of the book, I would like first to clarify what we mean by judicial dialogue, and also what is novel in how we planned the research approach of the book. So by judicial dialogue, we refer to the use of the preliminary reference procedure, but also more generally in how courts are using each other's reasoning. We explored various dimensions and types of judicial dialogue, such as horizontal between courts within the same member states, also vertical, that is interaction between domestic judiciaries, between domestic court and European courts. Transnational dialogue, which refers to the judicial interaction between domestic courts from different member states, but also at the dialogue between the Court of Justice of the European Union and the European Court of Human Rights. And then we identify different types of judicial dialogue based on the outcome of conflict of norm resolutions. And for instance, I refer to conform interpretation, disapplication of domestic law in favor of applying directly the Return Directive, or mutual recognition. All 27 authors of the book were asked to identify and analyze instances of judicial dialogue, explain what were the potential motives for judicial dialogue or lack thereof, and the outcomes of judicial dialogue on coherent and uniform implementation of directive, on rights protection, and also on allocation of institutional powers. An additional novel aspect of the research is that we try to team up judges and lawyers which are actually those who had first-hand experience in the exercise of judicial dialogue with scholars. And so the involvement of national practitioners has actually allowed a collection of a wealth of domestic jurisprudence, and at the same time also its contextualization against domestic legal, political, and social background that would have otherwise been impossible. And these multiple perspectives have allowed us to obtain solid conclusions on the book's main questions. First, has judicial dialogue contributed to a more coherent application of the Return Directive across Europe, or has it resulted in an even more complex legal situation than before such dialogue took place? Second, can judicial dialogue resolve the tension between the regulatory framework envisaged by the directive and the member states' immigration regime, and under which conditions? And third, have judicial interaction enhanced the protection of fundamental rights of individuals, and if so, in what way? And I would like to highlight 3 specific examples of judicial dialogue that I've taken from part 1 of the book. And these show quite a mixed picture of successes and failure in achieving the 3 main objectives. And by those objectives, I refer to coherent interpretation and implementation of the directive, adaptation of domestic regulatory immigration regimes, and third, enhanced protection of individual rights. So first example is one where there is prolific judicial dialogue, which has achieved its objective of coherent interpretation and implementation. And I refer to the delimitation of the scope of application of the Return Directive. The second example I would like to discuss is where there is indeed prolific judicial dialogue. However, the objective of coherent interpretation and implementation of the directive has only partially been achieved. And this is not necessarily due to a lack of quality or quantity of judicial dialogue, but it's to an inner limitation of the judicial dialogue. And this example refers to securing priority of voluntary departure over forced returns. And I will explain in more detail later on. The third example I will discuss is where we have a snowball of judicial dialogue. But what is missing here is that it has actually insufficiently touched on the most thorny issue of normative clarification, and that is related to the definition of the risk of absconding. So I return now to the first example that I mentioned, and that is the added value of the outcome, the impact of the judicial dialogue on clarifying the scope of application of the Return Directive. And I would like to mention that this has been one of the most litigated issues on the implementation of the Return Directive. It actually was the subject of the first preliminary ruling on the Return Directive. And I reckon that the scope of application of the Return Directive would most likely continue to be one of the most litigated one if we have a look at the proposal of the European Commission. And as Tineke has already said, there's already quite high potential of blurring the lines between asylum proceeding and returns, particularly in border procedure. So definitely the establishing the scope of application of the Return Directive is an issue that is going to be subject of much more litigation if, of course, the proposal in the European Commission Pact are going to go in the way they have been drafted so far. So the conflict on the scope of application, I would say, has resulted so far from 2 major practices of the member states. First of all, member states have extended the scope of application of the Return Directive to the extent of engulfing asylum and citizenship related regimes. And for instance, continuing to treat third country nationals as returnees, although they have lodged asylum application, or still treating them as returnees, although they have developed family ties with EU citizens. A second phenomenon is that some of the member states have limited the scope of application of the Return Directive in favor of prioritizing use of criminal law for sanctioning irregular stay or irregular crossing of borders. The outcome of judicial dialogue has been quite clear on prioritizing asylum and citizenship regimes against or over return procedures, and limiting the member states' attempt to expedite return procedures by requiring the suspension of return decision until the asylum adjudication has been finalized with a final decision of courts in first appeal. And this is basically the Gnandi scenario. Limitation of member states' use of criminal law for sanctioning irregular stays, also a clear result of judicial dialogue, and in particular following the El-Dridi doctrine that has since 2011 spread across the member states, and of the Arib judgment in relation to the crossing of internal borders. Following this instance of judicial dialogue, member states can resort to criminal law for sanctioning irregular stay or crossing a border only when the Return Directive has already been applied and failed to ensure return of irregularly staying third country nationals. And that is the Selaj or Chelaj scenario. Now I go to the second example that I mentioned before, and that is the impact of the judicial dialogue on prioritizing voluntary departure over first return. Thank you, Federica. This outcome has resulted from the judicial dialogue between the Court of Justice of the European Union and domestic courts, as well as from cross-citation of preliminary rulings. Nevertheless, the effectiveness of the judicial dialogue in this scenario is hindered, I would say, in three different ways. First of all, there is an inherent limitation of the judicial dialogue, namely that courts can only disapply a law, but it's at the end the responsibility of the legislator to amend laws that are incompatible, or domestic laws that are incompatible with the directive. And this seems to be the case still in Spain, who has a sort of atypical legislation imposing a fine and only then going straight away to the removal. And so this type of legislation continues to apply in spite of having two preliminary rulings pointing out clear issues in this design. In other jurisdictions, the lack of impact of the jurisprudence has actually deep rule of law connection. And I would invite you to read, for instance, the Polish chapter, which shows the disregards of judgment by the administration. I would also like to invite you to read, for instance, the Italian chapter, which signals that there is an issue with the judicial independence of the Giudice di Pace, who are those judges responsible for reviewing return-related decisions. Now, the second example shows that the judicial dialogue has to be accompanied by legislative intervention to correct poor transpositions. Other chapters in part one point out that the success of the judicial dialogue does not reside in quantity, but in managing to touch on the core issues of interpretation. And this is the case of the definition of the risk of absconding, which is a key notion of the Return Directive, the legal basis for many of the measures introduced by the directive, and which is defined with striking economy in the directive. Now, the less controversial part of this, the definition of the risk of absconding, has been subject to the preliminary ruling, and judicial dialogue has contributed to clarify where the risk of absconding has to be defined, in what type of instrument. Nevertheless, I would say that what is more controversial in the definition of the risk of absconding is how we define objective criteria, indicating that in practice there is actually a risk of absconding of the returnee. And so far, this has not been subject to a preliminary ruling as in clear and concrete guidelines. There have been few and scattered replies in different cases. So this is a scope for future judicial dialogue. In conclusion, I would say the key conclusion of the book is that contrary to the persistent opposition and critique of governments, courts have played a significant role in shaping the return policy along the lines of how it was intended to be from the onset, based on the rule of law, firm but proportionate, human, not hostile. And I would say that the role of courts and judicial dialogue will become even more important within the current context of expediting returns, limitation of the number of courts scrutinizing board procedure, which is a likely outcome of the proposal in the Pact on Asylum and Migration, rule of law backlash, and the limitation of legal aid. The chapter of this book definitely illustrates many more other various instances of judicial dialogue, conflict, and concrete impact of courts on return procedures. But unfortunately, I have only exhausted my allocated time. So what I would like to say is I would like to invite you to read them and reflect upon the conclusions made in these chapters. Thank you very much. And also thank you, Federica, for being patient with me.
No, you're perfectly on time, and you really squeeze so many elements of the analysis. And one of the things that is emerging from what you're saying is that we have really a dialogue that is emerging among courts, but also there's a kind of third element that is missing, at least from what is emerging. So the legislator sometimes is reluctant to take the hints and suggestions that comes from the courts, from the practice of the courts, in order to improve and to address the problems that are emerging. So this is something that is what is emerging from the practice. So I would like now to give the floor to Galina Cornelisse, that is also an editor of this book with Madalena. She's settled in Amsterdam, where she's associate professor, but and her expertise on this topic is really huge, and I'm really happy to give her the floor and learn from her experience on this, on the judicial dialogue and on the specificity that is emerging in this sector. So please, Galina, the floor is yours, and feel free to start, or if you have a PowerPoint now.
Thank you, Frederica. First of all, Madalena, you surprised me by your kind words. I have to replicate. I learned a lot from you as well. It was not only a pleasure editing this book, it was quite a long process with hard work. And I'm very sorry that we can't have a glass of wine tonight, which we planned, but I'm sure we will do so in the future. But thanks for all this cooperation. It was, I enjoyed it. Okay. I will start with some reflections on judicial dialogue in a plurality of legal orders, and I made a bit of a visualization to zoom in on something that I find very striking when we look at this particular area of harmonization. So I'm going to try to share my screen, and then I can explain you what I mean. I think I'm sharing now. Can you see this?
Not yet. Not yet.
Not yet. There's screen sharing, but there's not. Oh, no.
Okay, let me see, because it said that it was paused. I'm going to try again now. Share screen. I don't know why it doesn't want to share the screen that I want to share. Sorry, I'm going to do a new share.
Yeah.
It always works preparing the meeting and then. I have no idea. Wait a second. Maybe it's in the Word form. No. Right, I'm just going to stop sharing and try once more because it's. Okay, I'll try to do it differently. Yes. No.
Galina, I can try to share it myself. So
yeah, can you? I mean, I don't
yes.
know what. Yeah, I think now it should be visible.
It is.
The Word document. I had it a bit more smooth, but it doesn't really matter. So what I wanted to focus on is when we look at the regulation of irregular migration in the EU, and we look at it through the lens of judicial interaction and harmonization, we see some very special things happening. So the first thing that is striking, I think, is that EU action is characterized by procedural harmonization. So there's no harmonization when it comes to irregular migration on substance. And I think that has very much to do with the fact that it's extremely difficult for member states to find political agreement on substance when it comes to irregular migration. And this is also visible when from the very start of the area without internal borders, there was the Commission emphasized that we also need a policy on legal migration, but member states were mostly driven by the wish to guard their borders. So we see this also in Article 97 of the Treaty on the Functioning of the EU, that it is about combating and preventing irregular migration. And this means that all harmonization in this area is with regard to procedure and not to substance, which I find very interesting when I compare it to more traditional, the earlier forms of European integration, where it was mostly substance that determined the path of integration. And so substance impacted on procedure. You can see that with regard to free movement of persons. You can see that with regard to citizenship, very substantive, often normative, politically driven ideals that eventually, because of case law, had an impact on procedures that national states followed. Here it's the other way around. Here we have a kind of an emptiness when it comes to ideas. It's just about preventing and combating. And so there are all kinds of rules in place to achieve not a specific idea. So that's the first thing that struck me. Now, what happens is that this happens in a plurality of legal orders. So it's not just procedural rules that are codified by the EU legislator, but we also have national procedures. We also have national substantive rules on irregular migration. And then we also have the ECHR. And what happens when, and I think it is not just because of the emphasis on procedure, but I think the emphasis on procedure at the EU level facilitates the emergence of inconsistencies between orders and perhaps also gaps and unnecessary complexities, because the legislator doesn't depart from a certain ideal. So this facilitates the clashing of certain ideas. I will make this clear by zooming a little bit more in on irregular migration and criminalization. But another example, and I think Tineke already mentioned it in her opening, another example is public order grounds for detention, where obviously one can still maintain, okay, that kind of detention still has to be with the view of deportation, but it kind of forgets the complexity for the judge who has to operationalize a concept of proportionality. Because how does one then know if that detention is proportionate? Is it with a view to deportation, or is it with a view to how dangerous this person is? So there is no kind of overarching idea how these rules are supposed to operate with regard to other legal orders, principles already formulated in other legal orders, and also with regard to the domestic system. And I think another complexity that we see because of this emphasis on procedural harmonization, and actually Tineke was already mentioning the border procedure in EU asylum law. There we see a similar problem happening. It's very difficult to design a European procedure and then leave it to domestic judges to kind of fit that in their national. Those are systems that have a long history, and it sometimes it increases complexity. So then we see this administrative complexity. I think I've heard also people deciding about detention that in order to act in conformity with all the European Union rules, they really need more time, because the boxes to be ticked are more. And I'm not sure if it always increases the quality of decision making. I think a pertinent problem here is also that for legal aid workers, it becomes very complex to defend the interests of clients. So that is a problem. Now, how do we, because we're talking about judicial interaction, the judicial dialogue, so how do I fit in the judicial dialogue? And I think there's two things here, and those are on my screen 3 and 4. So I think in the first place, we can easily see that this emphasis on procedural harmonization within a plurality of legal orders makes the task of the domestic judge most complex. And this is for two reasons. I mean, there are more reasons, but I think the main reason is that the task of the Court of Justice of the EU, and I don't want to denigrate anybody, but I mean that the court officially in the preliminary ruling procedure is just doing a judgment on the interpretation of EU law. And of course, the court has to think of how EU relates to the ECHR. It does sometimes take into account application of domestic laws. Officially, they cannot do it, but of course, reading the judgment, it's clear that they think about it. But the EU is not a member to the ECHR. The EU always kind of, the court emphasizes that. But the domestic judge has to make sure that EU law is applied in its national procedural law. And in addition, that member state is a member also to the ECHR. So that brings in a lot of complexity. And again, we can see that, I think, very well in the case that I deal with in my chapter, where I look at criminalization of irregular stay, and where you see that the Netherlands chose an approach to criminalize illegal stay in a qualified way. So not every irregularly staying migrant was criminalized, but only those that had committed criminal offenses. And in the past, these people would be declared undesirable aliens. But after Europeanization, after the implementation of the Return Directive, we couldn't use this label of undesirable alien anymore. And we used the entry ban to kind of indicate this qualified illegal stay. And so irregular migrants as such are not, they cannot be criminalized. They are not subject to criminal sanctions, but only those that also have an entry ban. Now in Urami, the court decided that an entry ban can only start running after one leaves the territory. And that left this it was almost a bomb in the Netherlands, because then all the third country nationals that had not left the Netherlands after they got their entry ban, they couldn't be criminally prosecuted. And I mean, I myself don't think this is a bad thing at all, because I think normative, the normative dimension of criminalizing irregular stay is very questionable. But it does show the complexity of of a national judge that has to deal with that. And our national judge, our highest court, referred the question to the Court of Justice. The judgment was done in September, and there we also saw something very interesting, because the court, and I was very happy to see that it did so, took into account the plurality of legal orders, and in a very interesting way referred to the fact that penal sanctions, if they are used by the member states, also have to be in conformity with the ECHR. Now, I would have liked very much the court to go a little bit further, and I can understand that the court didn't do it, but I would appeal to all legal aid workers and national judges listening here to next time pose a question to the Court of Justice about the conformity of penal sanctions for irregular stay with European criminal procedural law. I think this would be a very, very nice example of my fourth point, where we see that this emphasis on procedural harmonization, and no matter how technical the Court of Justice tries to keep its approach, it will result in an incremental move towards substantial harmonization. I think it's an inevitable result. And I think in that way, although I do agree with most of the criticism that the LIBE committee is voicing on the new proposals, but I'm also optimistic, because I think that no matter how restrictively one legislates, the very fact of that legislation also brings in questions in the legal arena that were previously merely political questions. So, for example, this obligation to cooperate in the recast Return Directive, which is questionable in many ways, also because it refers to the asylum procedure, etc., etc. But I also think when we combine that with the criminalization of irregular stay, and then to put down in administrative law an obligation to cooperate, that might raise, again, very interesting, not purely procedural questions, but also substantive questions of justice that suddenly can be addressed in a court of law instead of just in a political arena. I don't know how much time I still have. Not so much, I think. 5 minutes, great. Okay, let me see, because I had some other, so another thing that maybe would be interesting to mention in this constellation is that we have the EU directive on the presumption of innocence, where it's very clear that the burden of proof should be on the prosecution. Now, how does that relate to the practice in many member states with regard to prosecuting irregular stay? And why are those questions not yet raised? I'd be really interested to hear about that. I had some other instances. Oh, yes. I thought I wouldn't have time for that, but maybe I can try to do it in a very brief period of time. I think another good example, and it's also something that Tineke already referred a little bit to in her opening, a good example where we see an incremental move towards substantial harmonization by through the use of judicial dialogue, or as a result of judicial dialogue, is the space that has been carved out by the Court of Justice because of questions posed by national judges between irregular migration on the one hand and the asylum acquis on the other hand. So cases such as Abdida, where somebody suffering from a serious illness cannot be subject to return. But that is a question that cannot be addressed, according to the Court of Justice, when it comes to the simple application of the asylum acquis. So that also means that some of the proposals in the recast procedures directive and the return directive are simply not lawful. because if it means that the risk of non-refoulement on non-asylum-related grounds or international protection as protected by the Qualification Directive, if they cannot be addressed, then there has to be a scope in the judicial review of the return decision, and that needs to have suspensive effect. So that's another example where I think we see very clearly an incremental move towards substantial harmonization, even though the emphasis, because of I would say, lack of vision, an emphasis on procedural harmonization. But I think judges here cannot keep their hands off these questions. So it will eventually lead through substantial harmonization. And I think I'm about to finish. I would say that sometimes we hear criticism on judges, that judges would go too far, or judicial activism. But I think it can't be differently. With this this emphasis on procedural harmonization, there will not be any other way for judges to tackle these questions. Thank you.
Thank you, Galina. This was very, very interesting because looking from the perspective of the procedural autonomy of member states, we should have a situation where instead the substantive aspects should be can be regulated depending on the competencies by the EU, and then leave to the national member states the opportunity to decide autonomously on the procedure in this very specific case, in this very specific area. The procedural element is even, it's the opposite situation where the procedure takes over the substance. But as you were mentioning clearly, this is not that is related, is not left behind, because at one point it will emerge and it will require the attention and the need for judges to take that into account. So now it is even easier to leave the floor to one of the judges that have been involved in the project, and I'm happy to have one of the judges from the Court of Justice of the European Union, but former Vice President of the Supreme Administrative Court of Lithuania, and President of the and then Supreme Court. President of the Supreme Court of Administrative Court of Lithuania. So we have a person that have been both in the position of the national courts as a national court and as a European court. It is so I am very happy to leave the floor to Irmantas Yarukais. Sorry for my pronunciation. I beg your pardon, and please take control of the Zoom system, and please, if you, I know you have a PowerPoint presentation, so
no, I won't do this. No.
Okay, so good. Please.
Okay, thanks a lot for such kind introduction. Actually, yes, I thought myself that I mean it was good opportunity to participate in the project, because at the beginning I looked at it from the perspective of a national judge. Actually, I dealt with quite a lot of cases related to the implementation of the Return Directive, and now I could look at it from other perspective. So it's really fascinating. Of course, I would like to thank organizers of this event and to congratulate all colleagues. It's a really timely book, because basically I thought that it's a 10th anniversary, because member states had to implement it from December of 2010. So 10 years, it's a really good time spent to evaluate to what extent objectives of that directive were achieved. So I was asked to speak by organizers of this event about the importance of vertical judicial interaction in the implementation of the Return Directive. And Madalina already introduced a bit what does it mean from the perspective of this book. So first of all, I would like to speak a bit in general about the preliminary rulings procedure, because of course when we speak about dialogue between national courts and the CJ, we speak in essence about the preliminary rulings procedure. And then to speak specifically about it from the point of view in the context of the Return Directive, how it looks both from national perspective and from the European perspective. Of course, when we speak about the preliminary rulings procedure, as we understand it all, basically we speak about the unity and effectiveness of EU law at the national level. And when discussion starts turning about this procedure, I always remember a joke about a man who decided to become a monk. So basically there is a man who decided to become a monk. He comes to the monastery and he says, well, look, I want to become a monk. And basically the council of elders says, yes, no problems, you could become a monk, but of course you will have to work in our monastery, because of course you have to make something for a living. Yes, no problem. And they ask, could you write? Yes, no problem, I could write. And then they said, then, well, we'll entrust you with making copies of old manuscripts in order for the saint word to survive, or not to forget it. We have to make copies of the saint word. But because you are a new one, basically you will write from copy and make new copy. So he starts writing, making those copies, and after some time, elders summon him and say, well, you do really good job. So now we'll entrust you really sensitive job. You will start making copies from the original. He is really satisfied because, of course, he feels that he deserved with his job. So basically, he starts his job, and one day he comes out of his cave with very big eyes, saying, "Guys, I found a problem." And they ask, "So what's the problem?" "Look, there is a copy, older copy. It's written celibate, but look at the original. It's written celebrate." So basically, for me, preliminary rulings procedure is about that. So basically, if EU law provides for some rights, of course, these rights should be uniformly protected and ensured at the national level. If it comes to the obligations, then again, these should be efficiently ensured at the national level. And of course, this is particularly true in the context of the Return Directive when we speak about protection of fundamental rights. Of course, needless to say that yes, the role of national courts from that perspective is essential. So when we speak about the importance and about the vertical judicial dialogue, so for me, at least two questions could be posed. One is, what does it mean vertical? And then how to measure that importance. Probably there are some kind of quantitative, qualitative criteria allowing to us to judge to what extent these objectives of this dialogue were achieved. So as Madalina explained, and I fully share that approach, for me, the term vertical here is basically to distinguish from horizontal dialogue. So basically that's dialogue between national courts. It depends very much on national traditions. For example, if we look at the jurisprudence of the Supreme Administrative Court of Lithuania is virtually absent. there is no tradition it could be very rare to refer to jurisprudence of courts of other states. So basically that's horizontal, and of course to some extent you could say that it's vertical in a sense that of course in case of conflict EU law is above, if it's possible to say so, above the national law. In other respects, in terms of content of cooperation, for me it's really a dialogue between partners, between equal partners, and of course the role of national courts is crucial. Why? Because basically they decide whether at all to initiate this dialogue, when to ask, how to frame questions, and of course jurisprudence of DCJ fully reflects that, basically saying that there is a presumption of importance of those questions, and for example in case interpretation of national law provided by national court, and for example national government is given, DCJ always says that interpretation of national court prevails, etc., etc. Then if look simply at statistics, basically around 70% of all cases brought before the ECJ, these are of course preliminary rulings. So again, in terms of quantity, the majority of cases come from national courts. And of course, it's not the quantity, is basically, again, there is quite a lot of academic research on this subject, but everybody agrees that the input for development of national courts is crucial. For example, starting from Van Genden Loos, Costa versus Senel, Simmental, Frankovic, all those grand cases, basically this jurisprudence is developed on the basis of demands of national courts. Of course, simply because of the fact that basically national courts face real problems of application of EU law at national level, and then of course it's up to the ECJ to take this into account. And of course, again, quite a lot of research saying that basically this dialogue adds some additional legitimacy, if you want, to EU law, because of course, again, it's a question of effectiveness of EU law, as some authors say that by putting EU law in the mouth of national courts, basically DCJ gives teeth of national courts, because of course then all national law could be applicable in order to enforce it. And of course now this role of national courts is clearly reflected after the Lisbon Treaty in Article 19 of the Treaty on the European Union, basically saying that member states have the obligation to provide effective legal remedies in the fields covered by EU law. So of course by that of course national judicial system is meant. Then the other question, how to measure a quality of this judicial dialogue. So as I mentioned, on the one hand there is probably quantity, but then there is a question of quality of that judicial dialogue, and I thought that one of the possible approaches is basically to ask a question: to what extent national courts behave like EU courts, basically to what extent they contribute to interpretation of EU law by providing arguments or motives related to interpretation of EU law or the Return Directive in particular in the demands for preliminary ruling. Of course, here my analysis is a bit shallow, in a sense that I had a time to look only at the judgments of DCJ, summarizing arguments of the court. So in order to provide detailed analysis, one has to look at the orders of reference, but still the information is quite telling. And here, both in general and when it comes to interpretation of the Return Directive, one may see two different patterns or degrees of engagement of national courts. So on the one hand, there are cases where national courts simply state facts of the case and provide information about regulation at national level. But on the other hand, there is an increasing number of preliminary references where national courts do not only that, but basically they provide arguments related to interpretation of EU law. So, and sometimes you could see even proposed answers to the questions they ask themselves. So this is really interesting trend. And in fact, this issue is reflected in a new edition of recommendations to national courts and tribunals issued by the ECJ in 2019. If you look at the paragraph 18 of these recommendations, it says that referring court or tribunal may also briefly state its views on the answer to be given to the questions referred for a preliminary ruling. That information may be useful to the court, particularly where it is called upon to give a preliminary ruling in an expedited or urgent procedure. So from the point of ECJ, of course, such approach is really welcome. On the other hand, several years ago, there was a discussion within ACA Europe, so Association for the Council of State and Supreme Administrative Jurisdiction, and this namely on the preliminary references procedure. And this discussion basically revealed very different approaches to what extent national courts are willing to participate or even may participate in such a kind of dialogue from the point of view of national law and traditions. And here I'm not speaking about some member states where disciplinary procedure could be initiated simply of the fact that you initiated preliminary rulings procedure. But sometimes this approach, national approach, is rather rigid. Just to give you one example, in 2016, the ECJ, the Grand Chamber of the ECJ, ruled in the Ognyanov case, where a national Bulgarian judge indicated that simply because of the fact that he describes factual and legal context in the main proceedings, he has to disqualify itself because from the point of view of national law, he already gave some hints, some ideas what this case is all about. And of course, the answer of the ECJ was that, of course, it's not possible from the point of view of Article 267 to allow such approach, because that's the essence of the preliminary rulings procedure. Because before without factual and legal context at the national level, it's not even possible to speak about providing the answer to the questions posed. So to conclude here, basically, I would say that in terms of content, the nature of the preliminary rulings procedure is more horizontal than vertical. Now, turning specifically to the Return Directive, so one aspect was already mentioned, that it's interesting that its development and adoption was heavily influenced by jurisprudence of the Strasbourg Court, and again, this is acknowledged directly by jurisprudence of the ECJ. Again, if we look at the quantity statistics in 10 years, 30 preliminary rulings, so it's a really impressive number, and from those, it's more related probably already to the quality. From those 10 cases treated by the Grand Chamber, Why? I think at least two explanations are possible. So one thing that, of course, it's very sensitive area. It was already noted that on the one hand, you have a horizontal division of power between the executive and judiciary. So the question of intensity of judicial review. Then, of course, there is a question of vertical distribution of powers. Again, this issue was mentioned. Is a question, for example, to what extent contents of the Return Directive encroaches upon jurisdiction of member states in the field of criminal law. So, of course, all these questions related to the delimitation of powers are very sensitive. And the other explanation, of course, related to the first one is that there is really high percentage of references for preliminary rulings where national court asks not fewer questions of interpretation of EU law, but basically these are questions concerning conformity of national law vis-a-vis EU law. So again, this indicates a certain sensitivity, and of course, again, it probably reflects all those troubles related to the adoption of the Return Directive.
Sorry, Irmantas, sorry to interrupt you, but we have 2 minutes more, and then I will ask you to close.
Okay, so just to finish about the quality that I started speaking about in the context of the Return Directive. So basically here again, one may see the same pattern. On the one hand, there are cases where national courts simply describe a factual situation, national regulation, and pose questions. But still, I would say that even in these cases, one may read a position of national courts between lines, especially when national court pose questions related to the question to what extent national law is in line with EU law. All cases starting from Kazoev, Eldridi, etc. On the other hand, as I mentioned, there are cases where national courts engage in this real dialogue, explaining how and why particular provision of the Return Directive should be interpreted in a certain way. And for me, a very good example, it's a case Thai Li Pham concerning interpretation of the Article 16 of the Return Directive, where basically German Federal Court clearly says that, well, on the one hand, I understand your jurisprudence, but still we have a jurisprudence, and I forgot to mention that there is even more complexity than Galina explained, because of course in many states there are constitutional courts, so you have to follow jurisprudence of the constitutional court. And this case is good from that, a good example from that perspective, because basically the court says, on the one hand, there is your jurisprudence, but then there is jurisprudence of German constitutional court in the field of preventive detention. And they, in some respects, they say that yes, consent of detainee could be taken into account. So what does it mean from the point of view of Article 16 of the Return Directive? And of course, what I say here, so basically it's not the end in itself, but from the point of ECJ, it's really very good to have all those arguments, both in order to better understand the national context, and then, of course, to weight all those arguments provided by national courts in a particular case in order to give a quality judgment. Because really there are many cases when sometimes it's, as you understand, judges come from different member states. Of course, they are not specialists of national law of particular country. So this clear description of national framework is really very important, and because of that, of course, as I mentioned, the Court of Justice urges national courts to come with complete picture. So to conclude, I think that this dialogue in terms of the Return Directive is really of good quality. To look to the future, I counted at least 11 preliminary references still pending. It means that this dialogue is far from being over, and given the fact that it's very sensitive field, I have no doubt that there will be more cases coming. So thank you very much for your attention.
Thank you very much, Mantas. It was really interesting, and I'm really sorry to have to stop you and to limit your time, but it's really a need to take into account also the time to be devoted to the other participants. And first of all, I would like to thank you, because this is really something that sometimes is perceived as a top-down intervention of the Court of Justice, saying that, well, okay, the Court of Justice is the ruler, and the national courts are the ones that are rule takers. This is not the case, because the dialogue is really an even level between national courts and the Court of Justice. So this is really an important point that should be highlighted and emphasized, because otherwise we may always see that the national courts as followers, whereas in reality they are the triggers to this dialogue. So this is really relevant. Sorry, now I leave the floor to another judge that will be presenting his own experience regarding the Greece legal system. So Sergios Kofinis, which is coming from the first instance court of Thessaloniki and the Independent Appeals Committee. So I leave the floor to you, and I'm really happy to have the opportunity to listen to one of the judges that are tackling the difficult issues of return and decisions in one of the countries more requested, more as Italy, in this effort to take into account migrants and asylum seekers. So Sergios, the floor is yours. Please feel free to take the control.
Thank you. I will now share the screen. I will try to do it. I think that work now?
Yes.
You can all see the, okay, very good. Okay, first of all, I would also like to thank on behalf of my co-author, Mrs. Leza Papanagiotou, and personally, the editors of the book for all the hard work they did, and also for the invitation to speak on this webinar. So in the limited time I have, I will not go through the chapters step by step, but I will try to focus on 2 or 3 main issues arising from our findings regarding the Greek court's case law on detention of irregular migrants and rejected asylum seekers. First of all, it is important to mention that in Greece, as in a few other EU countries, as we can see in the book, the administrative judge of first instance, that is the case of me, is the detention judge. It's more appropriate since administrative judges are also immigration and asylum judges. However, to follow here Adam Blissa and David Kossar's classification in their chapter in the book, they are still generalist judges as opposed to specialized judges. Why is that? Because any administrative judge, whether she has any experience or training on immigration or asylum law or not, may review detention orders. So the legal remedy available is called objection against detention, and it has 3 main characteristics. First, the decision is taken in closed session. There is no appeal against it, no appeal available, and the decision has to be issued on the same day or the next day in the worst case scenario, leaving little room for extended reasoning, as you can easily understand. So this leads to the second point I want to make. How can judicial dialogue work in such circumstances, if it can work at all? This is a way, I think, to address the question posed by the organizers of this webinar. Why do we see different patterns of judicial dialogue in the member states when it comes to particular questions of return policy? So to start with vertical judicial interaction, Mr. Yarkaitis made the point of how important it is to pose preliminary questions to the Court of Justice in order to get it involved in the process of interpretation of the Return Directive. However, this comes in stark contradiction with the internal law's requirement for a swift judgment. This requirement stems not only from the usual need to speed up judicial procedures, but is, I think, a fundamental aspect of detention cases. You cannot keep a person locked up even for a single day more than what is really required. When that person challenges the detention order, it is of paramount importance to give an answer to that request immediately. Now, how long would it take to make a preliminary reference? First of all, it should take the judge a bit more than a few hours to write it down, of course. Especially since the judge is not a specialized detention judge. She would have to pinpoint the legal question, go through all the relevant case law, make sure that there is no clear answer to the question in the case law of the CJU, and then proceed with the actual writing of a reasoned decision with a preliminary reference. This would take at least a few days, and then it would take a few more days to send the question to the CJU, and then the court would activate the urgent preliminary ruling procedure, which lasts up to 5 months, I think, from what we see with these kind of decisions. So that would take a total of probably 6 months before the final decision is issued. And by that time, the immigrant might be already free because of the time limits on detention, or the return decision may have already been executed, or she might have had to spend 6 months in detention in conditions that more often than not are quite bad. So the time factor is a deterrent, I think, for preliminary references. It is also important to note that first instance judges are, on the one hand, in general, reluctant to pose preliminary questions, not even internally. We don't really do it even to the Green Council of the state. And on the other hand, they treat detention cases as interim measures cases, that is, as cases of lesser importance. To some extent, that happens because the law itself refers to the provisions regarding interim measures when it comes to the procedural rules to be followed in objections against detentions. The result of all that is that there has been no preliminary reference from Greens on matters of detention, and I wouldn't expect any one coming up anytime soon, to tell you the truth. However, it is interesting that judges often cite CJU and or ECTHR case law in their decisions. Okay, I'm not saying that the citation is always correct, but judges use this mode of vertical dialogue quite often. There are two reasons for that. First, the lack of internal case law. Since there is no appeal procedure, there is no internal jurisprudence from appellate court or from the Council of State that first instance judges can turn to for guidance. So they rely on the case law of Luxembourg and Strasbourg. Second, since some administrative judges are indeed specialized immigration judges, especially in Athens and Saloniki, and also asylum judges nowadays, they keep up with the case law of the two European courts in the subject and can easily draw on it when necessary. Now, the second aspect of judicial interactions is horizontal judicial dialogue. As I have already mentioned, there is no appeal available, so there is no dialogue between direct dialogue between courts in Greece. However, it is interesting how horizontal judicial dialogue starts to evolve in Greece slowly after the full implementation of a national electronic case management system that allows all national administrative judges to have full access to every judgment issued by any administrative court in the country. This way, judges interact with each other by the way of reading each other's judgments, and they follow one or the other line of argumentation. This doesn't eliminate the risk of a split case law, but it limits, I think, the possible outcomes. Okay. Finally, one cannot find in detention judgments any transnational judicial dialogue going on, mainly because of time constraints. Can be easily understood. I think that it just doesn't have the time or energy to search national jurisprudence or legislation from other member states, especially the very limited time that she has to issue a decision on detention cases, but also because first instance judges are generally not accustomed to using comparative law tools, since they usually rely on internal higher courts jurisprudence. So to try to give an answer to the question of the organizers that I mentioned before, we can see that the patterns of judicial dialogue developing in Greece regarding detention cases are directly linked to the structure of the legal remedy available to migrants to challenge detention orders. The judge is constrained by this remedy regarding the types of judicial interaction she might engage in. Based on the above, the final question I want to address is this: does this make a difference in the implementation of the directive? Do these constraints have an impact on the actual protection of migrants in detention? We have identified with Mrs. Lesa Panagiotou in our paper 9 controversial issues arising in the context of objections against pre-removal detention. I believe some may be common throughout Europe. The first one is that are third country nationals who submit a request for asylum before the authorities of the detention center where they are held pending return considered to stay illegally according to the Return Directive? Can prior convictions and pending criminal procedures be taken into account when examining the risk of absconding? Do administrative judges have the power to review the conditions of detention or not? Is it legal to issue a so-called restrictive measure of compulsory stay in the pre-removal detention center for third country nationals after the 18-month time limit of detention has expired? And does this fall within the reviewing authority of the detention judge? Do judges have the authority and the obligation to review ex officio every decision issued every 3 months regarding the continuation of detention? How should cases of unaccompanied minors be dealt with? How should cases of ill or disabled third country nationals be dealt with? Can alternative measures be imposed to migrants that don't meet the standards for detention? And how should cases of rejected asylum seekers that make subsequent applications be dealt with? Okay, so there are quite a lot of issues that come up. I'm not going to go through all the different solutions that Greek judges have given to these problems. I am just going to focus on 2 examples where there is an obvious case law split. First, conditions of detention, and second, the duration of detention. Now, regarding the question whether judges have the power to review the conditions of detention, the greatest influence on the Greek case law on this matter has been undoubtedly the relevant jurisprudence of the Strasbourg Court. AA versus Greece of 2010 and RT versus Greece of 2016 are 2 good examples of judgments that have found that the lack of an efficient legal remedy for challenging the lawfulness of detention on the basis of poor living conditions constitutes a violation of Article 5, Paragraph 4 of the Convention. However, we can see in the case law that not all judges, first instance judges in Greece, have read these judgments the same way. There are decisions, for example, that rejects its inadmissible complaints invoking the conditions of detention on the ground that in the context of the remedy of objections, the court has no power to review the living conditions of detainees. And they cite the above mentioned Strasbourg case law as proof that the objections against detention is not a suitable remedy for this cause. The majority nowadays, on the other hand, examines these complaints in the merit. But even within this majority, there are at least two distinct strains of case law. Some decisions put the burden of proof of the conditions of detention on the detainee exclusively, whereas others allow for a lower standard of proof in general, and then either dismiss the objections because they find the conditions to be decent, or they order the transfer of the detainee to another facility, a facility that's more suitable for keeping people. Okay, the second issue is not a very complex one. It is quite clear.
Sorry, just
Yes.
to let you know that you have 3-4 minutes maximum.
I will not need any more. 2 minutes
good.
will be enough. And now, the second issue is not a very complex one. It's quite clear from the case law of the CJEU that the maximum duration of pre-removal detention is 18 months. However, at some point in 2014, the question arose in Greece, what should be done with migrants who had reached the maximum time limit of detention and could still not be removed from the country. Okay. The Legal Council of the State, which is a non-judiciary body of, let's say, state lawyers, issued an opinion suggesting to the Ministry of Interior that in cases of irregular migrants whose return decisions cannot be executed due to a lack of cooperation on their behalf, a restrictive measure of compulsory stay in the pre-removal detention center may be automatically imposed upon the foreign national until he or she cooperates with the competent authorities. So, of course, quite a few of those migrants brought objections against these so-called restrictive measures before the detention judge. Most judges upheld the objections and annulled the administrative decisions as unlawful because they constituted, according to the reasoning, a de facto detention order, which went beyond the 18-time limit. However, in a few cases, judges adopted a restrictive view on the scope of the legal remedy of objections, and thus on the judicial powers of review of these de facto detention decisions. They rejected the objections as inadmissible due to the absence of competence of the detention judge. Their argument was that the remedy of objections was only provided for in case of a detention decision and not in case of an alternative measures decision. I think that the lack of a second level jurisdiction here and all the constraints I have mentioned earlier concerning preliminary references to the Court of Justice are a main obstacle in the homogenization of the jurisprudence in these areas. Now, some of the issues raised above and raised in our chapter may, of course, be resolved when and if the recast Return Directive enters into force. However, other issues will most certainly arise, and the need for judicial dialogue will emerge once more. Thank you very much.
Thank you, Sergio. And this was very interesting, and also highlight how the possibility to engage in judicial dialogue is not just an opportunity, but is an effort that is to be taken by judges in terms of time, in terms of research, in terms of preparation. So it's not just a matter of having this opportunity that is an easy path. It's really an effort that could be taken. And also the fact that you were mentioning that this is not just an element in terms of activity, but also the opportunity to take the Court of Justice decision within each decision as a citation is also a step in this direction. So it's not, there are many ways in which the courts may engage in a dialogue indirectly, possibly sometimes silently engage in this dialogue. So this is very interesting and very relevant. So given that my work as a chair has not been so effective, and I have still for discussant plus the participants, the attendees of this webinar, I'm sure eager to intervene and to present their views and their comments. I kindly ask the attendees to start writing down their questions in the chat for us to be sure that we have all of them taken into account. And then we will start the discussion after the 4 discussants that we have. So I will immediately leave the floor to Daniel Tim, that is currently at the UI. I'm sorry that we are not able to meet in person, but he is currently a Fernand fellow at the UI, though it was originally from University of Scotland, and is and at the moment currently holding the Jean Monnet Chair of European and International Public Law. But please, Daniel, the floor is yours. I have to ask you to stay within the 10 minutes limit, and so we can still have some more time for the discussion. Please.
Let me start by expressing my gratitude for the invitation and the immense effort you put into organizing this event. I'm very glad to be here. Time is scarce, so I limit myself to 4 to 5, depending on the time, interrelated short aspects. First, courts and politics. The book starts with a bold statement. The very first sentence of the introduction reads, let me quote, "This book analyzes how courts and judicial dialogue shape return policies in the EU." Wow, I thought. Politics are shaped by courts and judges, not by politicians. The following sentences introduce some more subtlety into the argument. I learned that change did not necessarily emanate from the judgments as such, but rather from the contents of the Return Directive, which is then interpreted by judges. So the sequence is rather, first, politicians adopt the Return Directive, which was not as ugly and bad as some initially thought. Second, it's then interpreted by judges, and these judgments change policies, in particular at the national level. In the light of this constitutional separation of powers, these sequence matters, of course, and it matters in particular when politicians or the legislature decides to change statutory rules. And that is happening at the moment, as Tineke Street reminded us, and she is rapporteur for the directive for the Libe Committee. So she was the right person to remind us of the ongoing change that the Commission, for instance, proposes to introduce a more specific and also narrow understanding of the risk of absconding, and that it wants to abolish mandatory time periods for voluntary departures. So my question in particular to Galina and Madalina would be, how would courts react to that change? Would they still shape policies in the sense that they counterbalance the view of the legislature, as you indicate on page 21 of the introduction? Or would they rather say, well, the legislature has changed the law, so our jurisprudence will change as well? Of course, that also depends on how much they bring fundamental rights into the picture, but that's my first point and also my first question to you. Second, the element of time. It's widely known by all of us that judges do not only pronounce what the legislature decided, they are not only the bouche de la loi, as Montesquieu famously said, they often have some leeway, in particular when it comes to interpreting open-ended statutory rules, which are very widespread in supranational legislation. And a perfect example is, of course, the case law, which the various contributions to the book discuss so well. The first judgments, in particular on criminalization, were certainly very dynamic, also considering that criminal law was outside the scope of the directive. Other judgments are a bit more were to be expected. Take the case law on voluntary departure and entry bans, which more or less replicate the wording and the general structure of the directive. They still have a massive impact at the national level, but this impact flows rather from the contents of the directive. And then we have other case law on the risk of absconding in particular, which Madalena analyzes in her chapter, which she describes as conservative, which it certainly was, also because the legislature decided to refer to national law in the definition. This brings me to my question, which is probably a question to all contributors and panelists. Does time play a certain role in these different outcomes? Is it a coincidence that the very first case law was very dynamic on criminal sanctions, while more recent judgments are more conservative, also in their style of argument? Some may know an article I have written on the 159 ECJ judgments on migration and asylum law, which was published in the European Journal of Migration and Law, for which I've used the term administrative mindset. I mean, they focus on the wording, the general scheme, the drafting history, the telos of legislation. That is a conservative style of argument, which, by the way, does not necessarily lead to state-friendly outcomes if the contents of the legislation is not necessarily state-friendly. So does time play a role in how dynamic judges are? My third point, multi-level dialogue. In a way, it's trite and trivial to say that the EU is a multi-level policy and that the effects of supranational law depend on national implementation and domestic courts. And even though that is self-evident, it's still extremely important to say why that understanding is rarely taken seriously. And that, to me, is really the biggest added value of the book, why it is such a great and good book. It really brings together the European level with the domestic perspective via courts. And in doing so, it unearths really some fascinating showcase examples which are ignored and which are lost when you concentrate at the European level only, which some researchers unfortunately do. And the case in point is the Knandi judgment, which Galina discusses in her chapter. If you address Knandi from an EU law perspective only, you might perceive it as a restrictive judgment in the sense of migrant rights. By contrast, if you approach it from the domestic Dutch context or the German context, similarly, it can be perceived or at least used by domestic actors as an instrument enhancing the rights of migrants. So this multi-level perspective is really important and to me is the biggest added value of the book. My fourth point is national discrepancies. The lesson, I mean, the biggest lesson which I took with me from reading the book is how much national context matters, or to put it differently, differences between the member state greatly influence how EU law is received in the member states and how it works in the member states. In a way, we have not one EU law, but we have 27 EU laws, not least in a field like return, because the practical effects will always depend on the 27 national contexts. These differences concern both formal rules, like procedural prescriptions, but also the institutional setups, and the more informal practices, what you might describe as legal culture, which is of course more difficult to unearth in also in academic writing, but which is still highly relevant. How self-confident are domestic courts in terms of correcting the administration, for instance? A great example we just heard from Greece, Stergios, who explained us the procedural idiosyncrasies, why we have so little references from Greek courts on the Return Directive. Another telling example why context matters is the question of court jurisdiction. I learned, for instance, that in the case of Belgium and Italy, it can be a disadvantage that jurisdiction to review removal detention is given to judges who do not usually deal with migratory matters, be it the criminal judge or the Italian peace judge. That is all described very well by Alessio Di Pasquale and Sylvie Soriala in her chapters. Still, in the German case, the reverse conclusion is true. In Germany, it's not the administrative judge who usually deals with migration, but the ordinary judge, and that had the effect that they were actually much stricter than the usual immigration law judge would be. So it really depends on the context how you will work, and it's also difficult to develop like an abstract model what's best. It really depends on the more formal and also the more informal domestic practices in context, what's appropriate in terms of implementation. Fifthly and finally, the sound of silence. We all know that ECJ judgments are what you may call the proverbial tip of the iceberg. The ECJ deals with very few cases only, and even more so how these cases work in practice depends on domestic actors taking up these cases. And the usual narrative I would explain to students and others is that the more formal interaction between domestic courts and the ECJ we have, the more dialogue, the more respect for EU law you may find in the domestic legal orders. And by contrast, no references are an indication that there are problems and disobedience. And that may, as a rule of thumb, be correct. But still, I learned also from the book that the overall picture is a bit more nuanced than this binary reference is good, non-reference is a sign of problems. On the one hand, we have countries like France, where domestic courts, according to the chapter at least, use the preliminary reference in an instrumental manner to protect domestic leeway by the authorities, and that's the chapter by Serge Sloma. On the other hand, silence by means of non-reference can also mean different things. It can mean, indeed, that there are problems, that it's an indication of disobedience towards EU law, like in the case of Cyprus. But on the other hand, silence can also mean that domestic practices are already good, either because you have a very strong constitutional court, or you have domestic laws which are quite simply adequate. So silence can also mean just everything is fine. So no need for references, but it could also mean that domestic judges are listening nonetheless. They may not actively communicate with the ECJ, but they may passively communicate, as I also learned the Greek judges to a certain extent do. I mean, they cite ECJ cases. So there is a dialogue, even if that dialogue is not necessarily integrated in a 267 procedure. So again, the picture is a bit more complex. References are not necessarily a sign of loyalty towards EU law, even though they often will be. And by contrast, silence can also mean many different things. So that, to conclude, and I hope I respected the time limit, is for me, I think, in essence, the biggest lesson, how much the national contexts differ. And that is why I can really recommend the book also to others. You learn a lot, not only about return policy, but about the functioning of the European judicial system more broadly.
Many thanks, Daniel. They're very interesting points, and I hope that we will have time also for Madalena and Corina, and also the Sergios and Montas to reply to your comments. But without further ado, I give the floor to Tomasz Molnar from the EU Fundamental Rights Agency. He have the legal research officer in the research and data unit, so he will provide us also his view from the data perspective for the quantitative analysis of the migration situation. So please, Tomasz, the floor is yours.
Thanks a lot, Madam Chair, for giving me the floor, and thanks for the kind introductory words. Also, let me express my gratitude for the invitation. It's great to be in this setting and to discuss issues of common interest when it comes to returns. After Professor Tim's very nice, kind of canvassing the issues which are set out in the book approach, I will zoom in on one specific issue, which is the risk of absconding and the assessment of the risk of absconding. It's also subject to one chapter, it's chapter 5 of the book, excellently and eloquently written by Madalena. So in my intervention, I just would like to focus on the fundamental rights implications of the new rules on the risk of absconding as set out in the recast proposal of the Return Directive, and to see the challenges and the concerns. Just to recall the background of this issue, the recast proposal of the Return Directive, wanted to reshape the landscape, wishes to reshape the landscape in this regard as well. The explanatory memorandum to the proposal argues that there's a strong need for an EU-wide objective criteria for the determination of the existence of risk of absconding, and to prevent diverging or ineffective interpretations. The proposal sets out a common, non-exhaustive list of objective criteria to determine the existence of such risk. The definition of the risk of absconding remains unchanged, so it's the same. And then the brand new stuff comes in Article 6, which sets out for the first time at EU level, at the supranational level, a list of objective criteria containing 16 items. It's quite a lot, but it's still a minimum list. It's an open list, which merges elements, in a way, all of the elements from the Return Handbook, which is a soft law instrument, and the 2017 Commission recommendation on making returns more effective. So in a way, there's nothing new under the sun, but from soft law, there's a move to hard law. And it also operates with the rebuttable presumption of certain scenarios of the risk of absconding under the same circumstances as in the previously mentioned soft law documents, except for the secondary movements scenario. And it goes without saying that risk of absconding remains as one of the grounds permitting pre-removal detention. So it's interestingly linked to ordering detention, hence the problems arise. All right, so in the following, I would like to focus on 4 clusters of fundamental rights considerations and the problems with this new concept. First one, the open-ended list of criteria to establish the existence of risk of absconding. We know here that the point of departure is Al-Khodor, where the EU court ruled that national law must prescribe such objective criteria. It must be black-letter law. Court jurisprudence does not suffice. But the court, the EU court, didn't request to have an EU harmonized list to be fixed in EU law. So there's no such a requirement, which is in a way a bit hidden, and it's part of the Commission's argument. But to ensure clarity and enforceability, such an EU level list needs to be exhaustive, containing clearly defined criteria. And here it's not the case. It's an open list. It's an open list, meaning member states still can carve out and include further objective criteria in their domestic law. Plus, the proposal does not give justification for the approach taken. So it's a bit taken for granted, but there's nothing in the explanatory memorandum or elsewhere in the proposal, which essentially gives free hands to member states to provide for additional criteria in their national law. So there's harmonization, but it can be as wide as one can conceive. Second, assessment of all circumstances of the individual case. It's good that the overall assessment is a must also under the new proposed rules, but none of the indicators prescribed member states to take into account other indicators that may point to the absence of a risk of absconding. So such counter indicators can include the age and the health or social conditions of the person, as well as the presence of family members or social networks, a long period of stay, you name it. Interestingly, the Return Handbook, as a soft law instrument, refers to those counterindications, but it's not in the recast proposal. And if those rules will become binding law, then national authorities will in practice mainly look at factors pointing to a risk of absconding and not to those indicating the absence of that risk. So here it's a bit tilted. The text of the proposal only looks at the indications and not which would militate against that. And again, the Return Handbook takes a more nuanced approach. Apparently, that was not the full source of inspiration, since the Return Handbook gives additional guidance about non-automaticity. So irregular entry and or stay cannot automatically lead to the existence of risk of absconding, or in an individual case based on a case-by-case examination, the authorities can conclude that there's no risk of absconding even if one or more criteria in national law are fulfilled. So this kind of approach is missing from the text. Third, so the suitability of the criteria to determine risk of absconding. There are, as I mentioned, 16 criteria, which taken together cover an extensive range of situations. And framed as legal obligations, their formulation raises issues. They are not always, how to say, legal terms or legally tangible indications. Some overlap, others are so general in their scope that it prevents their uniform or foreseeable interpretation at the member state level. Plus, some criteria in themselves raise serious fundamental rights issues. I would like to mention 3 clusters. The first one is the criterion of an existing conviction for a criminal offense. This duplicates the proposed additional detention grounds under the new rules covering a risk to public policy, public security, or national security, which will be a separate ground under the Return Directive recast. Second, unless the past criminal behavior has clear relevance for establishing a risk of absconding in an individual case, any deprivation of liberty based on this argument could be seen as being arbitrary and having a punitive rather than preventive nature. And the wording is conceived in a manner which covers any criminal sentence, regardless of the severity or the date of the commission of the crime. So even petty offenses several decades ago. The second example, the ongoing criminal investigations or proceedings. This is one of the newly introduced criteria. In case of an ongoing criminal procedure, this is up to the competent criminal court to decide on such a measure, typically the the pre-trial detention. And this is rigorously regulated in domestic criminal laws, as it entails a limitation of the presumption of innocence, as well as deprivation of liberty. So the use of administrative detention this way would mean bypassing this mechanism. Plus, if it's not only applied to the accused, but only to the suspects, since the text is quite vague on that, it opens further doors. Theoretically, even one might argue that it can apply to anyone from a suspect or accused to even a witness or a victim, since just involvement in ongoing criminal investigations, it can be anything. Finally, in those member states that criminalize irregular entry and stay, this criterion could lead to a general assumption of a risk of absconding for all irregular migrants. And the last example, if we take together the lack of documentation, unauthorized entry, and the use of false or forged identity documents, these taken together assume a risk of absconding virtually to all persons who came to the EU fleeing persecution or from an armed conflict. So again, it's problematic. And last, the last considerations, the fourth one, it's reversing the burden of proof. This is really serious, since in 4 scenarios, risk of absconding is presumed, such as using false or forged ID documents, or if someone opposes violently the return procedure, not complying with an entry ban, or not complying with any measure aimed at preventing the risk of absconding, such as reporting obligations. This is problematic, since the existence of a rebuttable presumption cannot fully absolve the national authorities of having to conduct a proper individual assessment of each case and to seek evidence both in favor and against concluding the existence of such a risk. The CJEU also clarified that in relation to an asylum case, in case of applicants coming from safe countries of origin, which also operate with a rebuttable presumption of safety. So the court ruled that the authority must still carry out a fair and comprehensive examination. And the rebuttable presumptions must be without prejudice to the right to be heard and the right to an effective remedy. And these safeguards are nowhere in the new proposal, so at least explicitly. And for each of the 4 proposed criteria, one can imagine situations where a third country national returnee would typically face serious obstacles to rebut the assumption that the person will abscond. Just to give you an example, a child has been apprehended, and because he or she didn't understand the situation, acted violently just at the moment of apprehension. So if taken literally, it can be a risk of absconding, and that a minor can find himself or herself in detention. So all this rebutting this presumption, which is rebuttable, may easily leads to arbitrary detention when detention is not as a measure of last resort, it's not necessary and not proportionate. So to give up with something constructive, basing the decision on a full assessment of the individual case would make the system less likely to violate fundamental rights, more sustainable and more effective. So overall, and I leave it here, the proposed changes to the risk of absconding could lead to the prioritization of detention, more detention and more forced removal over less intrusive means. Please note the principle of gradualism as described in the book and as flows from the CJEU case law. With a high risk of arbitrary detention due to this new concept of risk of absconding. Sure, it is and it will remain quite an obvious terrain for national judges to engage in judicial dialogue in future on that matter as well. Thanks for your attention.
Thank you, Tamas. Your focus on the risk of absconding is really relevant, and you make the point of looking at what is missing or what should be improved in terms of the new regulation, the new intervention, legislative intervention. I would like to now give the floor to Caterina Molinari from the Leuven Institute of European Law, and I give you the floor, Caterina, and please again kindly ask you to limit your time to 10 minutes because we are running a little late. So we will take the opportunity to have some more time, but not so much given that unfortunately the limitation, the online version do not allow us no more than 15 to 20 minutes more than what was originally organized. Please, Caterina, the floor is yours.
Thank you, Federica, and thank you for the very interesting discussion and for having me today. So as agreed with Madalina and Galina, I will focus my intervention on the third part of the book, which is focused on judicial remedies and the role of judges in safeguarding procedural and fundamental rights. So I will first briefly go over what I think are the main findings of the chapters I was asked to comment on, and then I will raise 3 to 4 points of this further discussion if there will be time for that. Chapter 15 of the book deals with a right that is not regulated in detail in the Return Directive, which is the right to be heard. And besides the very interesting analysis of the case law by the author, it also shows that in instances where the legislation is not specific on regulating procedural rights, then there is the possibility for quite vivid judicial dialogue against the background of the Charter and the European Convention of Human Rights. So here, even if the author considers that the outcome reached by the Court of Justice is an underestimation of the potential of the right to be heard, still we can see that there is a real dialogue between courts. We're talking especially about vertical dialogue through preliminary rulings. while conversely, the chapter that deals with the right to an effective legal remedy reaches the opposite conclusion. So there we have Article 13 and 14 of the Return Directive, which regulate the right to an effective legal remedy to a good degree, and it would be even more, of course, with the proposed Return Directive. And here the author concludes that the dialogue between national courts and the Court of Justice has not been very substantial. And this leads him to argue that for a real coherent and correct implementation of EU law in the national legal orders, we would need much more than preliminary rulings. And in particular, he focuses on transnational dialogue, but also on the need for inbuilt mechanisms that ensure knowledge management within judicial systems. And this is a bit what Judge Kofinis has discussed with respect to Greece and the new administrative system for sharing of judgments. A rather pessimistic picture on vertical dialogue when courts do not want to engage with it emerges from the chapter 17, which zooms in on Poland in particular and describes Polish case law on return procedures that entail national security issues. So here we discover that Polish law in fact denies access to classified evidence to defense lawyers, even if they have security clearance, in case of return procedures, return orders adopted based on national security considerations. And Polish courts, administrative courts, have consistently refused to ask the Court of Justice whether this is compatible with the right of defense as an EU principle and a right. And this, even if lawyers, defense lawyers, have actively insisted on the need to refer preliminary rulings. Also, the chapter on children rights in return proceedings reaches the conclusion that dialogue here is hard to find. And this chapter is particularly interesting in highlighting the tension between effectiveness of fundamental right protection on the one hand, and effectiveness of return proceeding on the other, and the fact that effectiveness of return proceedings sometimes seem to be the overbearing consideration, and so that even the best interest of the children becomes just one of relevant considerations in return proceeding, but not the main one. And finally, the chapter on the lack of judicial dialogue on the prohibition of collective expulsion is very interesting in the examination of why there has not been judicial dialogue on this issue. The authors argue that first, there has been little judicial dialogue on the issue because the prohibition of collective expulsion essentially boils down to a requirement of individualization in decision-making, which corresponds also to the content of other rights in the EU legal order, for example, the right to be heard. So that then the courts can more easily engage with other rights and do not need to record to that. But even more interestingly, they argue that when collective expulsions really take place, then there is no access by third country national to the judiciary, so that judicial dialogue simply cannot be triggered. And this brings me to the second part of my presentation, and I would like to open it with this issue of access. So it is clear, and this book really underlines that judges and their dialogue has the potential to flesh out fundamental right protection much more than this is already in the legislation. But this is only possible if their country nationals can access the judiciary of a member state. And this leads me to my first question to the editors and the panelists. Which is, what do you think then of the cases when this trigger for judicial dialogue does not exist? And I'm referring in particular to remote control pullbacks practices. Do you think then that we should try to catch up with these practices by extending the jurisdiction of courts to these practices? And would this be conducive, considering that the more we legalize the AFSJ, and the more we see member states shying away from judicial control through informalization and externalization practices? Then a second issue that I see emerging from all the chapters that I've examined is the issue of vertical dialogue in the form of preliminary ruling as something that depends largely on the willingness and capabilities of national courts. So then one might wonder what the impact of this feature of the legal system of the Union is on fundamental rights, for example, in return proceedings, but not only. So this book is very enlightening in terms of the real functioning of the judicial structure in the European Union that relies very heavily on national courts, but is a voluntary mechanism, such as the preliminary ruling, really apt to the task. Thirdly, all the contributions highlight something that is really very prominent in the legislation and the case law, which is a contradiction between effective fundamental rights protection on the one hand and effective returns on the other. But as some previous speakers have already highlighted somehow, this contradiction might be more positive than real, at least in certain cases. So we know that, for example, voluntary return is both more effective, cost-effective, and more humane than forced return. So is it always the case that by reducing procedural standard, we achieve more effective return? And if not, then what can we do to change the rhetoric of the legislator on this issue? Because I think this really has an impact on fundamental rights. And my final point is on the role of the legislator and its interaction with the role of the judiciary, which has already been touched upon as well. So we see in the area of freedom, security, and justice an increased proceduralization of legislation. And this is what Galina has already discussed in her presentation. And she's very optimistic on the way this could lead to more protection of substantive rights as well. But I also see a danger there because the more we proceduralize in the legislation, and the more judges risk to be differential towards the standard of protection, which is often quite low that is set in the legislation. And so there is a risk, in fact, that the charter will somehow be interpreted in light of secondary law rather than the other way around. And that this would then have, let's say, a lowering effect also on the standards of protection in national law. And with this point, I would like to conclude and thank you again.
Thank you, Katarina. It was very, very interesting, and also looking at the two interpretations that can be given to effectiveness. So effectiveness of a remedy and effectiveness of protection. So it's really, really an interesting point. So now I leave the floor to our last but not least intervention by John Treyer, which is a researcher at the UI and able to speak and give us his fresh approach to to the book. Please, the floor is yours.
Thank you very much, Federica, for the introduction. I'll do my best to keep the time and be brief.
Thanks.
And thank you to the organisers for putting together this great event and for inviting me to participate as a discussant. Also, a word of congratulations to the editors and all of the contributors for a really fascinating, timely publication, which I really enjoyed reading. So regarding my brief intervention, I've been asked to provide some questions and comments, specifically on the theme of non-removability, a term which captures a range of situations in which a return decision cannot be enforced because of some practical or legal impediment to removal. So while the issue of non-removability represents a cross-cutting theme that is touched on in a number of contributions in the volume, it is also the subject of a dedicated chapter written by Jean-Baptiste Farcy, chapter 19, which will form the basis of my comments today. And the first comment I'd like to make is that I think this chapter does a really excellent job in framing the issue of non-removability within the wider discussion of judicial dialogue in the volume. So the main conclusions of the chapter in this respect are that situations of non-removability and related policy and fundamental rights issues are in many ways actually the product of different levels of judicial interaction on, respectively, the causes and consequences of constraints on member states' abilities to expel irregular migrants. So whereas fundamental rights impediments to expulsion, such as non-refoulement and related procedural safeguards, have been the subject of sustained transnational judicial dialogue between the European Court of Human Rights and the Court of Justice of the European Union, Farcy highlights how the consequences of non-removability, in terms of the rights and legal status of third country nationals, have been subjected to considerably less judicial scrutiny by these supranational courts, creating a legal void to be filled at the national level. These consequences of non-removability concern two main issues, as outlined in the chapter. The first relates to safeguards pending removal, which are regulated under Article 14 of the Return Directive and include a range of important social rights, while the second consequence relates to legal status, which, as Farsi explains, is an issue that both European courts have refrained from engaging with in the context of non-removability. Following from this, a question which struck me as particularly pertinent concerns which factors can help explain this lack of judicial dialogue on the consequences of non-removability. So on residents' rights under EU law, vertical judicial dialogue has underlined the reluctance of the CJEU to encroach on this area of national competence, as Farsi makes clear in his analysis of the rulings on regularization under the Return Directive and Qualification Directive in Mahdi and Mboj respectively. Hence his claims of the need to foster a rights-based approach to regularization through horizontal judicial dialogue at the national level. However, I'd be curious to ask why there has not been more judicial interaction on the question of safeguards pending removal, considering that these, unlike the issue of legal status, are expressly regulated by Article 14 of the Return Directive. So Farsi comments on how there's been sparse case law under this article at the national level, conclusions he reaches based on the empirical findings of the Redial project that Madalena referred to earlier, while the CJEU has only provided one ruling on this provision in Adida, which, although expansive in its interpretation of the need to cater more broadly to the basic needs of irregular migrants, is still careful not to be too prescriptive in detailing the content of these duties. So given that this provision can have an important safeguarding role in ensuring that migrants whose removal has been postponed are not deprived of basic social rights, especially in cases where regularization is not possible, I think it's interesting to hypothesize why there has not been greater contestation surrounding this provision, especially in light of examples given elsewhere in the volume of the role that vertical judicial dialogue has played in shaping legal norms under the directive to accommodate the fundamental rights claims of irregular migrants. So one potential answer for the lack of judicial engagement under Article 14 that I inferred from the chapter by Farsi is that domestic courts and the Court of Justice of the European Union have been to some extent disempowered by the formulation of the legal norm itself. Indeed, Farsi explains that Article 14 was watered down from the original Commission proposal to leave a wider margin of discretion to member states. This is reflected, for instance, in Recital 12 of the directive, which holds that the basic conditions of subsistence should be defined according to national legislation. So on this specific issue, I think the chapter is an important counterbalance to some of the other contributions in the volume, in that it highlights also some of the limits of vertical judicial dialogue in extending legally enforceable rights to irregular migrants under the Return Directive when these interpretations cannot be sustained by the text itself. This is evidenced, for instance, by the fact that the court in Abdida is careful to not stray too far from the text in formulating a right to social assistance. Another potential explanation can be found in one of the original Redial project reports, which uses the example of the Netherlands to highlight how national courts have prioritized the effectiveness of returns over fundamental rights by making access to social benefits conditional upon the cooperation of returnees, while also pointing to national constitutional safeguards on social rights, which might make appeal to the Return Directive and the Abdida judgment redundant. As such, there could be a number of factors at play here to explain the absence of judicial dialogue on the consequences of non-removability, particularly in terms of safeguards pending removal. But I think that the general approach of the volume to judicial dialogue provides an informative model for conceptualizing how situations of removability come about and why they are problematic in the first place. And this is very much highlighted in the chapter by Farsi. In light of this lack of judicial dialogue on the consequences of non-removability, my second question and point of focus relates to how judges might go about fostering more dialogue on safeguards pending return. For instance, are there arguments to be made under the Charter of Fundamental Rights to flesh out the duties under Article 14 in more concrete terms? This is a question which is not tackled explicitly in the chapter, and I think could maybe be an interesting follow-up question to some of Farsi's conclusions, particularly as a point of contrast to his discussion of the European Court of Human Rights' restrictive stance on destitution cases involving irregular migrants who are not also asylum seekers. Indeed, fundamental rights might be a good way of conceptualizing even circumventing Article 14, the Return Directive, which itself has a limited scope of application, covering only non-removability scenarios involving a postponement of a return decision, and therefore not extending social rights to all irregular migrants pending return. Then a third topic for discussion raised by the chapter concerns the question of alternative means of addressing this legal vacuum identified by Farsi, which has been created by EU law on non-removability. namely through legislative amendments to the relevant provisions of the Return Directive. This relates back to some of the comments in the prologue written by Fabian Lutz, where he considers arguments in favour of a more detailed regulation of the material situation of non-removable migrants at the EU level in order to ensure greater harmonisation of standards between member states. And as Lutz explains, these arguments do not exclusively touch on fundamental rights concerns, but also on potential benefits that greater harmonisation could bring to member states themselves, for instance, through discouraging secondary movements. So in this context, I was wondering whether some of the speakers or other panelists or contributors might also be interested in thinking about why there have been no further legislative developments on the situation of non-removable migrants, despite being recognised as an issue at the EU level for at least a decade. Why do we think, for instance, the proposal for a recast in 2018 has not advocated any changes in this respect? Does this ultimately all stem from a reluctance on the part of the member states, or are there maybe legitimate arguments that this could further frustrate the policy objective of more efficient returns? And then finally, looking to the future, some questions and comments about the recent pact on migration and asylum, and particularly the controversial and much discussed concept of return sponsorship under the solidarity mechanism. Here I'd be interested to know, or interested to hear thoughts on the implications of this mechanism for non-removable migrants, and particularly those whose return decision has not been formally postponed and who might therefore be relocated after 8 months, as Tina Kesterik was describing earlier. For instance, might fundamental rights and mutual trust play a role in these kinds of transfer scenarios? Will these kinds of scenarios require greater degrees of vertical and horizontal judicial dialogue and safeguards pending return? And might refusals to relocate after these 8 months lead to even more protracted in limbo scenarios? I guess this is all quite hypothetical at this stage, but maybe some questions to consider nonetheless. So thank you for your attention, and once again, congratulations on a great publication.
Thanks, John. It was very interesting, and you were mentioning many issues that could be tackled also not only by the panelists that are here, but also some of the attendees that are also participate as attendees at the moment, but are contributors to the book. So they are authors, and so we will be more than happy to welcome them. And I ask those who are tackling the technical part. So Angelica, please be so kind to allow all of them to participate, and so we can have the opportunity to discuss in a more, let's say, in the last 15 minutes of this event, in order to make sure that we can have the opportunity to highlight and to see if they also can contribute to this discussion. One item that I have to highlight is that unfortunately, given that we run over the time that was foreseen, Tina Kesterik has left, and we will not able to have her for the comments, though she was very happy to receive any comments and suggestions we may have. So she will be very happy to receive any of your additional comments directly to her. So so in order to make sure that we have the opportunity to participate, and I will give 5 minutes to Madalina and Galina, and you are to try to reply to as many questions as possible, and if you select them, and then I will also try to make the same effort for Sergius and Mantas if they want to contribute and to participate with us, and then have any other question that comes from the attendees to this discussion. So please, I kindly ask you to raise your hand to participate in the discussion. Otherwise, I cannot really cannot easily coordinate this discussion. So please, if you see, that's the kind of raised hand, and we will try to make sure that all of you will have the opportunity to participate in this discussion. Please, Madalina, the floor is yours.
Thank you, Federica. And first of all, I would like to thank again all the speakers and the discussants. I've learned a lot, again, new things from the presentation of the speakers, and also a very insightful reflection from the discussants. So thank you very much for spending time and reading chapters and also stating new ideas for new research that we have to continue invest in. I will not touch on all the points because some of the authors are here with us, and I think Jean-Baptiste Farcy is also attending, and I think he might want to respond directly to John's comments and also some of the comments by Katarina. But I want to touch on an issue that I think connects a lot of also what Daniel was said and connects many issues that have been raised today. And one issue that I've also encountered in my interviews and interaction with some of the judges that are working in returns. And it's this idea that we started actually the presentation of the book that proceduralization sometimes is leading to more protection of fundamental rights. But this is not necessarily true, as Katarina was saying, and I agree with that. Sometimes more proceduralization does not necessarily lead to more effective fundamental rights protection. And there I have in mind an example of given by Judge Bostian Zahler, and I think he's also present today with us. It very much depends how the directive or national legislation harmonizes procedural rules. It might be that these procedural harmonization actually codifies sufficient standards for protection of fundamental rights, but it's a double-edged sword. It might at the same time, depending on who is the government in charge and the policy agenda of that government, might fire back against the protection of fundamental rights and might actually lead to tidying up the hands of judicial interpretation of judges. So, you know, from a certain perspective, I think, and this is also what I've tried to emphasize a little bit in my presentation, that I don't see necessarily as a shortcoming of the current Return Directive, the regulatory flexibility that is embedded and it's allowed by this directive. Too much harmonization or procedural harmonization might not always lead to a clearer, more transparent or fundamental rights protection. But there needs to be a certain flexibility in interpreting the norms. And this flexibility is actually the one that fuels judicial dialogue, is the one that fuels exchanges of ideas and might lead to novel interpretation or new ideas. And one more thing that I wanted to say, and that I'm finishing with that, is this idea of what did we intended with the book, and whether when we refer to judicial dialogue shaping the return policies or shaping the implementation of the return policies. I have to say that we started this idea of the book 3 or even 4 years ago, when the recast of the Return Directive was not an option. And at that moment in time, what we were interested in how judicial dialogue and courts shape only the implementation of the Return Directive. Of course, now the discourse has changed because there's a new political agenda. But I would say that, again, judgments are legally binding for the executive and the legislature. So definitely these judgments and the judicial standards that have been created via judicial dialogue are mandatory and should shape also the policy choices in the recast directive. Now, whether this, the extent to which the recast will reflect the jurisprudence remains to be seen, because there we see from Tineke, there seems to be no agreement either in the European Parliament. But I hope, hopefully, I hope this book that we wrote is going to inform more policy making. And of course, we didn't have another, and that's the last idea, and perhaps it will be tackled on by Bostian and perhaps other judges who are attending as well at this event, is with this book, we wanted to emphasize that what is important for the implementation of policies, whether it's Return Directive, Asylum, and or the other directive, is not only what the Court of Justice is saying, but it's actually more interesting and more substantive and more contributive how the preliminary rulings are implemented at the national level. And this is a phase that is very often forgotten in the research. And this is what we attempted to do with this book, to explore exactly how judges using the preliminary rulings, and not only in the referring jurisdictions, but also in other jurisdictions. So I hope we try to depict as much as possible this picture, but I'm sure Galina has more to say on that. And again, thank you once more for all your reflections, criticisms, but also appreciations of the book.
Thanks, Madalena. Galina, please.
Yes, thank you. I'm going to be a little bit brief because I think it's very nice to leave the floor now to people who've been listening for a long time. I think I'm going to just discuss the questions regarding legalization. Daniel started with asking what is the relationship between the legislator and the courts, and I think Katarina elaborated a little bit also on that in the sense what can be are there always positive consequences or not, and I think it is true that the authors of the book have really shown the nuances that can occur there, so that it's not just a positive development. But what I think my main argument is, and what I really what struck me when I was editing the book and looking at all the arguments made by the contributors is precisely, and maybe I'm repeating myself, that what happens by EU legislation in this area is that we bring even if it may be stricter sometimes, we bring certain issues in a court of law. So we facilitate the making of arguments that used to be mainly political. I think the whole discussion about voluntary return is a very good case in point. I mean, there's no case law of the European Court on Human Rights on voluntary return because it was simply not something that would ever could ever be framed in a human rights argument. And how, I mean, I think the questions that Daniel also brought forward with regard to the relationship and the trias politica in that sense, that they're extremely interesting, but I need more time to think about it. Because, you know, it's not, the trias politica is not so simple at the EU level. I wouldn't even, you know, it's not even trias. There's much more actors. So I think that Katarina linked it a little bit to externalization. And again, I would need to think more about your remarks. I think they're extremely interesting, and they relate, of course, in a very obvious way to this, you know, fiction of non-entry. That I think I also discuss in my chapter where we see case law of the Court of Justice limiting the scope that member states have to use exceptions when they intercept people at internal borders. But I would need to think more. I can't give you a clear-cut answers, but your remarks provided a lot of food for thought. I think the other remarks I would really like to leave to the authors of the chapters, because I think they're very eager to start answering. But thank you very much for this, for a lot of the feedback that made me think a lot. Maybe we should write another book addressing these issues.
This is always, you finish up a book and then you start a new one. You start the organization of a new one, because everything in the meantime of the publication process, you learn and you start thinking of new things and you revise your ideas. So thank you, Galina. I would like to ask the book contributors, so Sergio, Imantas, but also I see that also Fasi and Bostian that are among the attendees, if they want to have their views and to help to provide their views on the issues that has been presented in this by the commentators, but also by the editors and other contributors.
Should I start?
Yes, please.
Okay, cool. Let me first thank Madalena and Galina for coordinating this book. I know how much effort you've put into making this a reality, and thank you very much. It's been a pleasure to read a few chapters so far. And also I want to thank John for his very supportive remarks and suggestions. And also you've raised very good questions. I just want to say that there's a new case delivered last month, LM, also on the issue of non-removability, and it's also a case coming from Belgium, like Abdida in 2014. And that's also a question that could come up, and why cases come from Belgium only on this issue, and why is there no dialogue coming from other countries. And in this LM case, the Court of Justice confirmed the Abdida judgment, and it did not say very much more on the status of non-removable migrants. So it's basically left to the national member states to decide. And I think one reason could be that we should look at the national context, like Daniel Tim said before, and member states have different solutions to this issue. I know in Germany they have the Duldung system, but in Belgium we don't have much for non-removable migrants, and I think there would be a need to harmonize this at EU level. But in the recast of the Return Directive, there's no proposal. I don't know why, and I would have liked to hear Denike Strick on this, but unfortunately she left. But as Galina said earlier, the Return Directive is very much on procedural harmonization, and we don't have much on substantial harmonization. And I think here it's basically the same. So the court leaves the issue open for member states, but sometimes, like Belgium, we have a void, and that's why we have preliminary rulings coming from Belgium, I think. But thanks again for all your questions, and I hope I addressed some of them.
Many thanks, Patti. I kindly ask also Bostian to have, if he wants, 2 minutes intervention, because unfortunately the time is running out, and we also have the participants leaving for other obligations coming. So please, Bostian, you want to add something, because you were asked for by Madalena?
I'm trying to unmute.
Yes, please.
Do you hear me now?
Yes.
Okay. Well, I would just like to say hello to friends and editors, perhaps especially to Jacek and Mantas. Well, I would just like to share with you perhaps my impression after 20 years of dealing with the asylum and immigration at the court. There is an enormous amount of quality literature already written by the researchers, academic, and also judges on the issue of the effective implementation of the EU law in the field of asylum and immigration. And for me, after hearing this panel, the question is, how we could get this good literature to the tables of the judges, to the presidents of the courts, perhaps to the judicial training centers. Because after all, this is just, I agree that these are complex cases that a judge has to combine national law, EU law, European Convention on Human Rights. But this is our job. So I think this is the strategic question, how to bring these materials that are very practical and help judges to apply not just EU law, but the rule of law. So in these terms, I think that the book is very relevant, not because of the new pact on asylum and immigration, but also of the situation of the rule of law in Europe, which is very particular. And I was particularly surprised by the conditions in which the judges in Greece have to deal with the detention cases. So that would be my impression after this very interesting panel. Thank you very much.
Thank you, Bastian. And then we can really have a closure for this event. It was really stimulating, interesting, and provides us a lot of information, but not only of what is currently the situation in asylum and migration law, but also what would happen and what will happen in the future. And I'm sure that the participants to this event will have learned a lot as I do. So I would like to thank again Angelica for the support, for all of you for the work, and I would like also to make sure that, given that this event was recorded, we will also circulate it across the CJC website in order to make sure that those who are not able to participate in at the moment will have opportunity to learn from you, but also to contact you later and to engage in a discussion also through emails and exchanging emails. So many thanks to all of you, and goodbye, and have a safe day. And then I cannot say have a safe travel home, because we are all at home at the moment. So enjoy and have a good evening. Bye bye.
Thank you very much.
Thank you. Thanks. Bye.
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 To all.
Bye bye.